Hello, everyone, and welcome back to the Universary. Today we have a small claims case where a tenant, Ms. Rebecca Hopson, is suing her landlord, Ms. Rebecca Robert, and her husband, James Robert, for um, return of her security deposit. Only the thing is, they still live in the rental unit. So this isn't a case of they've moved out and now they are saying that too much of their security deposit was withheld. Rather, they are still in the rental unit but want their security deposit returned. So we'll see what the judge thinks.
All right, are both of the parties here? I see Rebecca Robert, I see James Robert, and I see Rebecca Hopson. Okay, are you all able to hear me?
Yes.
Yes, Sean.
Okay, thank you. All right, I'm just opening up the court file in your cases. In your case. You're welcome, sir. Okay, so what I have here is the claim by the Hopson for $6,000 for returning a rental deposit. I'm going to ask you both, please raise your right hand, and do you each swear that the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Very good. All right, so this matter that has been brought by Rebecca Hopson. I want to make sure I understand your claim, and to do that, I'm going to ask you a couple questions, and then I might have some follow-ups in order to sort of zero in on what I consider to be the legal issues in the case. Okay. Mm-hmm. And if I do not correctly understand your claim, please tell me so that I do correctly understand your claim. So this is a claim based on a failure of a landlord to return a deposit on a lease. And also, if I understand right, you're asking the court to impose the statutory doubling provision for failing to return a deposit within the allowable time frame. Is that generally it?
Yes, asking the court to return the excess deposit based on the ordinance that prohibits security deposits from being more than 1 month's rent. So we're asking the court, the excess and the penalty provision. Yes.
Right. So then let me also make sure I understand this. You are currently still a tenant of the defendants?
Yes.
You're still living in the property that you're leasing?
Yes.
Okay. So that's what I thought when I read all of this material. And so that makes this unusual, at least from a legal point of view. And the reason I say that is because usually people file a lawsuit for the return of their deposit after the tenancy terminates and the property's been vacated, and we go from there. So it appears to me, and again, tell me if I do not understand your claim correctly, that your legal theory here is that when the original term of the lease expired and you embarked on a new term of the lease, that triggered the landlord's responsibility to return your deposit.
I guess if I could phrase it like this, Your Honor, it would be that we've had 3 separate consecutive leases. So the current lease that we signed and went into effect was after the ordinance was adopted into law. And the reason about having the excess security deposit. So the reason that we feel it should be returned is because the ordinance prohibits having a security deposit greater than 1 month's rent and went into effect before we signed our lease. And I guess we're asking the court for the question of, even though we've had 3 consecutive leases and we still live here, did the lease in fact go into effect after the ordinance was adopted? It wasn't a renewal. There's no language in the leases that create a renewal, or they could have done a renewal maybe with an amendment or something, but these were each 3 standalone separate leases with a very specific start date and ending date, even down to the hour, minute, and second. And the lease says that, like most leases, the deposit is returned and then, less damages. And then in this case, the Roberts chose to roll the deposit over. The deposit we paid in the first lease back in 2020 was rolled over into lease 2 and rolled over into lease 3. That was their prerogative to do that. And each lease, including the one we're in, the one in question, says right on it, lessor acknowledges receipt of the deposit. So it's our view that this deposit was, of course, paid to cover the new lease, which we are in right now, which was both signed and went into effect after the ordinance was adopted. So it is not retroactive because these leases were very separate, if I may. There's no term about it being a renewal. They're separate.
Well, that I understand that's your theory of how the law applies, which, as I did state in the beginning of our session today, sometimes comes as a surprise to people.
Right.
And I know part of your theory of this is based on an Olympia code and not necessarily on the state residential landlord tenant act. Okay. So presumably this is a question to you, Ms. Hopson, but it may require some input from Ms. Robert as well. Presumably, the money that you're talking about that's at issue here is currently being held in a trust. That it's currently being held in trust until at some point in the future the lease expires, and then the statutory process for determining the return of deposits takes place. I mean, Ms. Robert, is the money in a landlord's trust?
Yes, Your Honor. It's in a landlord trust with Pettit Property Management currently. We transferred the money when we hired the property manager.
Okay, so there's no claim here that the money's been appropriated or something like that?
No, Your Honor.
Okay. So I don't think, and again, I'm asking the parties to, correct me if I'm wrong, because I may not understand I may not understand the claim that you put forward, but there doesn't appear to me to be any factual disagreements here, right? You both agree that there's a lease, that you're living in the property, that you're renting from the defendants, that at 2 points in the past, the lease has been renewed or revived, or there's a legal dispute as to whether it's a new thing or it's a continuation of an old thing. And nobody disagrees as to where the money is or how much it is or what the various responsibilities of the parties are with regard to occupying the property or anything else. I mean, Ms. Hopson, is that true?
That sounds true to me, Your Honor.
Does that sound true to you, Ms. Robert?
Well, I think there are some disagreements about tenant responsibilities in the property, but that's sort of another conversation, I guess. With regard to the security deposit and the lease renewals that have happened, that's sort of the sticking point. Their attorney has developed this theory, and that it's a separate contract, and that we would have returned the security deposit to them at the end of one lease just for them to redeposit it at the beginning of the new lease. And this is a tenancy that started in 2020. That's when they paid the deposit. That's when it went into the trust account where it stayed. And so we are sort of confused by this whole thing as well. Like, we have been dealing with this for months, emails back and forth demanding money, and it's just not applicable because they are still residing in the home. They are scheduled to vacate the home on the 30th of April. They've been given proper notice.
Okay, yeah, I understand that what you're telling me there is that your disagreement is with the legal theory that's being advanced by Ms. Hopson here. Yeah. Okay. I get that. Okay. So this, in my view, comes down to a legal issue only, which, you know, in normal civil cases can be subject to a summary judgment kind of procedure, which I guess, you know, to explain it a little bit more, the parties essentially agree as to what the facts are. They disagree about how the law applies to those facts. And that, Ms. Hobson, in your case, you believe the outcome of the case should be that any money that you had on deposit should be refunded. And Ms. Robert takes the opposite position, that it should be retained until you finally depart, I guess, or you're finally no longer a tenant. And I mean, I've read what everybody submitted here. I've read the documents. I've read the ordinances, not just the, you know, revised Code of Washington Residential Landlord Tenant Act, but also the provisions of the Olympia ordinance that was, I think, fairly recently passed. Pandemic era ordinance, I guess it is. And I think, if you know, Ms. Hobson, I think that you're pointing me specifically to subsection 5.82.060 in the Olympia Municipal Code. Yeah. Okay. All right. Well, I mean, if the parties don't have anything else they want to add to this beyond what is already in the record, I think I'm prepared to rule on it.
I'm sorry. I think, yeah, I think I understood everything that Miss Robert was saying. I guess just that we weren't asking them that they should have definitely returned the entire deposit so we could give it back to them. You know, the rollover was how it naturally happened. We're just really disagreeing that there was any sort of renewal. I guess. I'm sorry. I tried to take a note while she was speaking, but you get a little nervous in these moments. So I'll leave it at that, Your Honor. Thank you.
Okay.
Yeah.
All right. Well, you know, as far as my understanding of the laws that as it relates to, you know, the landlord tenant issue, and, you know, the basic contracting issues involved in that, the parties have, you know, come to an agreement. They've expressed that agreement in the form of a lease. That lease was originally executed and has been renewed on 2 occasions. The parties are still performing their obligations under this contract or this lease. And the agreement, it mechanically, the agreement is essentially continuous. In other words, it was executed originally and it is still in effect. The parties have by agreement extended the application of the terms that they originally agreed to when they originally executed the lease in the beginning. Now, that among the many provisions of that lease is a deposit, and the deposit is defined not just by amount, but the deposit is also defined by what it's for. In other words, it's a guarantee of performance. It's a potential source of reimbursement for excessive damages beyond wear and tear, etc. It's also governed by statutory provisions that would require, in the event that the tenancy ends, which presumably it will at some point, obligate the landlord to return it within the allowable legal time frame, or return it minus any withholdings that are legally allowed, that the owner or the landlord would have to account for within the statutorily allowed time frame. That may mean that all of the deposit is going back to the tenant, or it may mean that something less than all is going back, but that's an eventuality that can't be predicted right now because the parties are still performing under the contract, and the triggering event for the return of the deposit has not yet occurred, which would be the end of the tenancy. Now, tenancies can end by various means, of course. There can be evictions, there can be abandonment, or just the end of the time specified and the lease not renewed. There are other triggering events that are explained in the Residential Landlord Tenant Act. So those provisions were put into effect prior to the enactment of the Olympia Municipal Code Section 582060 and are governed by the provisions of the contract that you wrote and signed and by the provisions of the Residential Landlord Tenant Act in effect at the time you executed it originally. So my ruling here is that there is no basis to find any damages have been proved. That is not to say that they might not be proved in the future, but again, that depends on the triggering event that would require the landlord to return the deposit or to return less than all of the deposit for statutorily authorized purposes or purposes that are authorized by the provisions of your agreement. That has not occurred yet. So my ruling is that there has been no claim proved, and so I'm going to enter finding in favor of the defense.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. All right, I've written up a judgment consistent with the ruling that I just announced, and the court clerk will file that, and it will be available to both parties later today.
Thank you.
Thank you.
All right, thank you, everybody.
Bye.
So I thought this case was really interesting. As an amateur layperson law nerd, I wondered if there might be somewhat of a case for damages if the tenant is claiming that the security deposit by law should have been held in a separate interest-bearing account, and then the security deposit should have been returned at the end of each lease period and then returned to the landlord for the start of the next one. So if you think about it, in 3 years, the landlord has had the benefit of the interest accrued on the security deposit going right back into the same account and increasing the amount of money earning interest. So there might, I suppose, potentially be a case for improper enrichment of the landlords who should have only gotten 1 year's worth of APR rather than 3 years building on each other. But that's a stretch. That's a really big stretch. And I came away from this case thinking that this sounds like a couple of people who are preparing to move, and it would be helpful if they had more cash funds available. So they're trying to get some. But that was just my read on it. Let me know your thoughts in the comments. Can't wait to hear from you. Hope you enjoyed.